The Institute of World Affairs at the University of Wisconsin-Milwaukee presents International Focus, a weekly discussion of the people and events behind today's global headlines. Support provided by Milwaukee Public Television and the UWM Center for International Education. Now here's your host, Doug Savage.
Welcome to International Focus. Congress's recent passage of the Justice Against Sponsors of Terrorism Act, or JASTA, over President Obama's veto is sending shockwaves across the international relations landscape. Critics say the law effectively takes decision-making on key foreign policy and national security matters out of the hands of responsible federal agencies and turns it over to tort lawyers, juries, and local judges. Central to the issue is the doctrine of sovereign immunity, which prevents foreign governments or their political subdivisions, departments, or agencies from being sued without their consent. Arguing against the new law, President Obama warned it would open the door to similar laws being passed in other nations that would expose U.S. personnel and assets to risk. Here to help us understand the implications of JASTA for U.S. foreign relations, we're joined once again by Robert Beck, Associate Professor of Political Science at the University of Wisconsin-Milwaukee, where his research, writing, and teaching focus on international law and foreign policy. In his spare time, he also serves as the university's Associate Vice Chancellor and Chief Information Officer. Bob, welcome back to International Focus.
Thanks, Doug. Glad to be here.
Well, I'd like to start with two takes on the recently passed law. First, from the Organization of Islamic Cooperation, who say this unilateral law is an invitation to serious chaos in international relations that upsets a firm and established international legal order and diminishes the integrity of the entire international legal system. White House spokesman Josh Earnest was a bit more terse. He said, it's the single most embarrassing thing the U.S. Senate has done. So, first of all, what does JASTA say?
JASTA is an elaboration and a modification of existing federal statutes related to sovereign immunity. The classic statement of sovereign immunity for U.S. laws, the Foreign Sovereign Immunities Act of 1976. And JASTA modifies both FSIA and also the Anti-Terrorism Act of 1990. Historically, the immunities from jurisdiction that were enjoyed by sovereigns under FSIA were relatively constrained, but the new JASTA legislation will expand the capacity both to bring suit with respect to a foreign state involved in terrorism, even if the actions are beyond U.S. borders, also renders susceptible to suit in federal court individuals, and there are some provisions for a 180-day waiting period in the event that there is an ongoing negotiation on a settlement between the U.S. government and a foreign government. That would have to be noted by the Secretary of State and then reported by the Department of Justice, and courts could have a stay of 180 days. But that's the essence, is an expansion of the jurisdiction that U.S. courts may have with respect to both foreign sovereigns and also individuals.
Well, it wasn't explicitly stated, but sort of the people on the receiving end of this new law pretty much knew who it was targeting, wasn't it? This is really, in many ways, a response to 9/11 and Saudi Arabia.
Yes, very much so. And I think the timing of the overriding of the veto is not coincidental, nor is the election. There was, I think, a fair amount of frustration among the 9/11 victim families that they were not able to really seek remediation within U.S. courts. A number of federal court decisions found under existing FSIA that the courts did not have jurisdiction. Meanwhile, there's been relatively little successful litigation with respect to the Guantanamo Tribunal, with only a relative handful of decisions rendered and at least four overturned. So there was great frustration, I think, among families. A lot of legislators had that same feeling as well, and that, coupled with the release of the 28 pages from the 9/11 Commission, which which called out by name a number of Saudi officials and suggested that they had some role perhaps in al-Qaeda, though the commission itself did not hold that the Saudi government per se was responsible, nor that senior officials were directly responsible. It, I think, somewhat finessed whether other Saudi government officials were involved, and the now made public 28 pages of the report document in some detail the alleged roles of some Saudi officials.
Well, and those 28 pages were subject to considerable spin. I mean, I think Saudi spokespeople are saying, yes, finally it all came out, and look, we've been exonerated, right?
Yes.
So it depends on which side of the fence you sit.
Yeah, that's exactly true. I mean, but there are names called and relationships identified and dots connected, but they're connected, I guess, in different ways depending on the political spin.
Well, it's interesting you mentioned sort of the lack of serious prosecution of the actual perpetrators, and some people have made a comparison to JASTA and the litigation that's likely to follow to the Goldman's family prosecution of civil action against O.J. Simpson. It's like we didn't win on the criminal side, but we're going to do it on the civil side.
I think that is not an altogether inapt comparison. I mean, the civil approach is one that has a certain attraction, and already there is a case that has been filed with respect to by the wife of one of the victims who was at the Pentagon, and there's another joint action that is expected to reach the courts really quite soon. So there's a lot waiting in the queue, and the civil route is the one that is being pursued now aggressively. And
as a class of interested litigants, I mean, the 9/11 victims were, as you suggest, pretty hard politically to ignore at this juncture, right?
Yes, and I think it's reflected in certainly the voting, where only one senator voted to sustain the president's veto, and even that was, I think, with some arm twisting by the president. This is a hard position to stake a claim against. Even Hillary Clinton was supportive of this legislation. And again, the coincidence of the 15th anniversary, the upcoming election, this visceral appeal, I think, and the sense that justice hasn't been done, I think is what has made this really an attractive approach. And yet there was, I think, insufficient appreciation of the broader implications for international law and international politics. But at the domestic level, there's a strong visceral appeal to the JASTA legislation.
And I think one that could be sort of a nod of approval, and then you move on for the typical American. But talk a little bit about how it's being perceived on the other side by the Saudis.
They're not pleased. They spent a lot of time lobbying against this, and a lot of money, millions of dollars, reportedly, in lobbying efforts. Adel Al-Jubeir, who was the foreign minister and the former ambassador to the United States, was personally involved. They have already indicated their concerns, but also their hopes that there will be tweaks and changes done. And already, as you and I were discussing before the show, already 28 U.S. legislators have had a bit of buyer's remorse and talked about amendments that might happen. But there is, I think, grave concern among the Saudis and Middle Eastern states more generally about the legal implications of JASTA. And already one prominent Saudi international lawyer has proposed a Saudi version of JASTA. There was already an Iranian version of JASTA and a Cuban version of JASTA. And we see a play of reciprocity, which is something that the Obama administration was warning would happen.
Well, and even beyond the legal realm, there were economic implications potentially, and there's sort of perhaps threats too strong a word, but indications that something not in U.S. economic interest may follow if this were to come to pass.
Yeah, and I think there were some more subtle than others suggestions that there's something like $750 billion in Saudi assets in the United States, and those could get moved around. And in fact, those are the assets that would be sought in any successful suit that might be brought under now the JASTA legislation. So it's not. It wouldn't just be a threat. It would make some sense to try to protect those assets. But of course, there would be significant economic implications if those assets, in some or all, were moved.
So talk a little bit about how that would work. I mean, if I'm successful in my suit as one of the American litigants, who am I actually suing, and what kinds of things might I reclaim?
The suit could be against an individual. Most of the discussions have been against that the suits would be brought against governments. Typically, when suits are brought, there has to be some recoverable assets within the jurisdiction of the United States. Legal scholars have suggested, for various procedural reasons, it might be pretty tricky to actually recover assets. So some of these victories may be more moral than practical, although lawyers are really resourceful about finding money and finding opportunities to recover it, and there certainly is a lot of money out there. Still, I think one of the limitations of any legal action would be the possibility of financial recovery, and at least one prominent scholar has raised this as an area of difficulty from a practical standpoint.
So, but at the core of this, from a legal perspective, is this doctrine of sovereign immunity. So talk a little bit about the origins of that and what in practice it is meant.
It is a venerable old international law doctrine. It's a lot like diplomatic immunity to the extent that it goes back hundreds of years. It's rooted in customary international law. It's viewed as really a foundational principle of international law. And it has as its origins the notion that states are sovereign equals, and that as sovereign equals they are entitled to certain immunities as sovereign equals. In diplomatic immunity, it means the state's diplomats are accorded on a reciprocal basis immunity. In the case of sovereign immunity, the states are accorded immunity from the jurisdiction of other states' courts. One thing that's not well understood about sovereign immunity, I think, by the general public is that it's really a pragmatic principle. It's based on reciprocal interests. It's not just something willy-nilly given away, as some might expect. So there's a reciprocity dimension, and also it's really key to success. Much like in diplomatic immunity, there's a reciprocity expectation.
So in some ways, it's almost has a certain parallels with conventions against torture, for example. Like Senator McCain was very vocal in his opposition to U.S. committing any sorts of act of torture, given his biography, saying, if we go down that road, what can we expect in terms of treatment for our prisoners who are captured?
Yeah, I think it's very common for Americans to say, what do we lose if we side with international law, but not to appreciate what do we gain? And many legal scholars and the Obama administration have emphasized that really the United States is probably the single greatest beneficiary from sovereign immunity, given our broad footprint, our broad engagement in international affairs, our multiple military operations. So there was a lot to gain from an American perspective with respect to sovereign immunity, and there's a lot potentially to lose if now other states pull their own versions of JASTA.
Well, let's talk in a little bit more detail about what some of those potential hazards may be. But first, we're going to take a short break. We'll be right back.
The Institute of World Affairs presents our community with a range of public programs relating to global issues, U.S. foreign policy, and the world economy. For more information about the Institute of World Affairs, call 414-229-3220 or visit our website at www.iwa.uwm.edu.
Welcome back. We're talking with political scientist Robert Beck about JASTA and sovereign immunity. So we're talking a little bit about sort of the ramifications for the loss of sovereign immunity for U.S. interests. So what might that be, say, for service people, for example?
The concern is that service personnel, other government officials could be subject to suit to the extent that we have military and humanitarian operations that are far-flung, that these could be somehow susceptible to suit. There have been particular discussions about drone warfare and whether that might be viewed as causing civil harm that would be subject to suit by other courts. And aside from the individual and government susceptibility to suit, there's also just the possibility of being subject to discovery. So the expectation that foreign courts would request government documents being turned over. So that in itself, the discovery aspect, could be highly intrusive.
So that would put the U.S. in a position of either compromising those kinds of intelligence assets if they complied with the discovery requests, or refusing, and that would prejudice their position in the litigation, right? So.
It could put the United States in a quite awkward situation. I mean, things could get messy quite quickly, and this is not a novel phenomenon. There have been attempts to render justice under other foreign jurisdictions, like secretaries of state, presidents, etc. But the possibility that sovereign immunity would be constrained seem much more likely in a post-JASTA world.
So, is this part of a larger process where it's been eroded, or is this sort of a novel turning point in the history of sovereign immunity?
I will spare you the lengthy disquisition on the evolution, but I can say that originally there was an absolute theory of sovereign immunity, and in fact one of the early cases in U.S. Supreme Court law was from 1812, in which sovereign immunity was held absolutely to be the case, and that was the famous Schooner Exchange versus McFadden case, where the French authorities had taken an American vessel and flagged it as a French vessel. It was driven into an American port, and the original owner said, "Hey, that's mine." And the U.S. Supreme Court held that this was a French vessel and was insusceptible to U.S. suit as a result. And though that would still have been immune even under a restrictive theory of sovereign immunity, at the time the Supreme Court really was sticking with an absolute theory of sovereign immunity. Increasingly in the mid-20th century, states became more and more acting like commercial entities. And that raised a challenge for law. What if and this was particularly true in socialist states where the factories were owned by the governments themselves. And then the question was, well, can you sue a government that's acting like a company? And both in American law, but also in international law, there came to be a more restrictive view that said there should be a commercial exception if a given state is actually acting like a company. So the Austrian Supreme Court in the Drala case held that Czechoslovakia could be subject to suit. There was a famous Tate letter that the U.S. government adduced that also endorsed this restrictive theory. And
so what kind of fact pattern would be involved in that instance? How were the governments acting like companies, and what kinds of actions opened the door to litigation?
Well, a relatively recent Supreme Court case was the Weltover case, in which Argentina issued bonds that were payable in New York, and then they failed to actually make good on the payment for those bonds. And the Supreme Court held in that case that this action was essentially a commercial one, and even though by by the time of the Weltover case, the Foreign Sovereign Immunities Act was operative. The Foreign Sovereign Immunities Act also has the Commercial Acts exception. So in that case, Argentina was held to be subject to proper suit, and in a classic or absolute world, they would not have been susceptible to suit. But the issuance of what they called bonans was viewed as a commercial act and thus subject to suit. Within a couple of years, though, of that Supreme Court case, there was the Amaretta Hess shipping case in which Argentina was also involved, and there Argentina was involved with a bombing of commercial vessels during the Falklands War, and in that instance, the U.S. Supreme Court said that was still subject to immunity from suit in U.S. courts.
Well, one of the other areas, and in fact on this program we've discussed from time to time, is aspects of the big multilateral trade agreements, particularly the ISDS, the investor-state dispute settlement, in which that is very often the bone of contention that leads to a lot of pushback against these. I mean, where in the state is subject to suit on behalf of a corporation. So if the corporation feels the state's laws are somehow harmful to their business, they can bring suit. Is that in any way related to this? I mean,
well, I think in general, international law will follow the evolution of state practice. It lags typically, and so as state practices evolve, they become more commercial, they become more global. The law will follow and try to address those circumstances. One could argue that JASTA is an early attempt to deal with circumstances in which at least allegedly states are involved with the sponsorship of terrorist activity and trying to render that insusceptible to immunity.
So, you mentioned earlier, there's shortly after the override, many of the legislators involved in, I think including some of the co-sponsors of the bill, said, okay, now we have to get to work on fixing what we've just done. So, first of all, what kinds of remedies do you think are available?
I think they could tweak a fair amount of the language, perhaps expanding the provisions for the capacity of the executive branch to ask for a stay with respect to the courts. They could perhaps change the circumstances under which, and narrow the circumstances under which a state might properly be subject to suit, maybe based on circumstance or location. I think the circumstances were so difficult for Congress to oppose this, but the implications just don't seem to have been adequately appreciated, and you have this ironic circumstance where Republican leadership is blaming the president for not telling them clearly enough what the problems were.
Right, and I mean, politically, it certainly was an issue that was the product of 9/11 and those victims, mainly in New York. Is that an option? I mean, could you say, okay, this is not now precedential over the whole landscape of international law, but in fact restricted to that particular set of circumstances?
I mean, I've heard different strategies that could be applied. It's possible that Congress could simply provide greater domestic redress, perhaps providing greater funds to the victims. It's possible that they could do more to just further investigate these claims. So they could walk away from possibly JASTA and seek other approaches that could remedy to some extent the circumstances without having what many view as problematic implications of really eroding a pillar of international law. And
if that doesn't come to pass, I mean, how quickly do you think that entire environment will change? I mean, you've mentioned there's already been calls in many other places to have sort of reciprocal laws?
If I had to guess, I'd say we'll see lots of suits because lawyers have these in the wings, and we'll see lots of efforts at reciprocity in other states because the whole dynamic of international law, but particularly areas on immunity, are driven by expectations of reciprocity. And as I said earlier, Doug, the United States, I think, disproportionately benefits from sovereign immunity, and as we see more and more efforts to constrain American immunity, I think the implications of JASTA will become clearer.
And this is an imponderable, perhaps, but once we get past the election, how easy will it be to walk this back, do you think?
I'm glad you said it's imponderable. I mean, I guess politicians can be skilled at that political tap dance, and stranger things have happened. I mean, this has been a remarkable time for American politics, as you know well. So it's possible that after the election, there certainly could be different incumbents in part. So that might change the dynamic. There will be a bit away from the 9/11 15th anniversary at that point, and we may have already seen a number of these suits brought forth. We may have seen various efforts elsewhere to change the law, and that could make it easier to pull off a revision or withdrawal.
Very good. Well, Robert Peck, thank you very much. We'll have to leave it at that. To our viewers, we'll see you next time on International Focus.
For information about the Institute of World Affairs and its many programs, or to become a member of the Institute, call 414-229-3220 or visit us at our website,